Cutler are next on our agenda, candidates for governor and lieutenant governor respectively. There are 4 grounds for objections listed. The first one is Ms. Cutler not submitting the affidavit of candidacy. The second is misstating Ms. Cutler's name on the nomination petition. The third is misstating Mr. Gluba's address on his affidavit of candidacy. And the fourth is a defective notary on Mr. Gluba's affidavit of candidacy. I'm going to start with the objection to Ms. Cutler's affidavit of candidacy. Before that, I think we have to deal with a couple issues to dispose of, a subpoena from one of my staff members to speak, and a motion for me to recuse myself because of the subpoena issue. Because they both involve me and my staff, I'm going to turn the panel over to Attorney General Bird.
So I think first we'll deal with the motion to recuse Secretary of State Paul Pate. Mr. Hurd, would you like to address your motion?
Yes. Thank you, Attorney General Bird. First, I would like to note that under a strict reading of Iowa Code Section 44.6, I believe, there's a question of whether Auditor Sand has the ability to recuse himself from this panel. That is an issue I raised in an email to the panel. But to move on to the specific motion, there was an initial request for Ms. Danny Phillips to, or for the Secretary of State's office to accept a subpoena on behalf of.
Mr. Hurd, could I clarify? Let's take the motions in order. So can we do the recusal of Secretary Pate first? We'll deal with that and then we'll go to the other ones.
Yes, and that's in relation to the motion. So a request was made for one of Secretary Pate's employees to provide testimony today. That request was denied. There was an additional request for her to voluntarily provide testimony. That was denied. There was a second subpoena request through 17A, in which this is a contested case from an executive or from an agency of the government. And under 17A, there is a requirement for the agency, this panel, to issue a subpoena upon request. That was also denied. We also attempted to serve Ms. Phillips in person through process server this morning, and we were given the runaround by the Secretary of State's office. Not Secretary Pate himself, but from his office. And ultimately, Ms. Phillips was not able to be subpoenaed, and I don't believe she's here to provide testimony. And her credibility is directly at issue in at least 2 of the objections. So I believe her testimony is necessary, or a credibility determination of her is necessary to determine these objections. And because Secretary Pate is her superior, her boss ultimately, I don't think he can be unbiased or impartial in making a determination of Ms. Phillips' credibility. Thank you.
Mr. Bull?
Yes, on behalf of the objector, Mr. Aerosmith, appreciate your time being here today. We would resist the motion to recuse Secretary Pate. As my friend said, it's not himself, it was his office that was in dealing with a lot of these issues. This is a supervisory relationship. Iowa law requires much more before a disqualification, we believe, is required. It requires a direct, definite conflict that's capable of demonstration. There's a lot of speculation here. We do not believe either under case law, under 17A, or the common law that there's a basis to have to be disqualified or recused. And frankly, we can get into the merits, but we believe the fact issues that this would present are not even legally relevant for this panel. We think there's a clearer way that the objection should be sustained. So for all those reasons, we would resist the motion to recuse.
All right, any questions from the panel? In taking a look at this motion, I would just note that it's not clear that 17A applies to this objection panel. That's not a settled matter of law. Would also note that the Iowa Code involves the Secretary of State as one of the objection panel members unless some very clear criteria are met. So the legislature clearly contemplated that the Secretary of State handles election filings. In fact, that's a very important part of his job and made him part of this panel. I personally don't see anything that disqualifies the Secretary from serving on this panel. This is the work of his office, so I'd be inclined to overrule this motion requiring his recusal.
May I be heard one more time? Attorney General?
Sure, if you have, especially if it relates to why you think the law requires him to be recused.
Yes, well, it relates to this panel deciding this motion. Under the code, the individuals required to rule on objections for non-party political organizations is the Secretary of State, Attorney General, Auditor of the State. Iowa code is very clear that the only time those three individuals are not supposed to pass on an objection is if the objection is to their nomination papers. This objection is not an objection to Auditor Sand's nomination papers. Therefore, there's question whether Mr. Secretary of Agriculture, Naig, has authority as a panel member to decide this motion and this objection.
So I think that's your second motion, we're just dealing with your first one, so did you have anything else to add on your first motion?
Yes, I would just add that Ms. Phillips, or I was provided 2 affidavits from Ms. Phillips, and I do not believe, well, I'll get on that issue later, that's a separate motion, but that'll be it for this motion.
Mr. Secretary, I can move that we overrule this pre-merit motion if you would like, or you can, whatever you'd like.
I would so move to override the motion to recuse Secretary of State, Pate, from the State Objection panel.
I second that. All in favor say aye.
Aye.
All opposed say no. The motion is overruled. Now we're on the second motion about the auditor recusal. Mr. Bird, I believe that was your motion as well.
Yes, thank you, Attorney General Bird. Under Iowa code, the 3 individuals, again, that are supposed to rule upon an objection for a non-party political organization is the Auditor, Attorney General, Secretary of State. The Iowa code is very clear that the only time one of those members is to not pass judgment is when the objection is to one of their nominating papers or nomination papers. This objection is not to Auditor Sand's nomination papers, and therefore I don't think he has authority to recuse himself from this panel. I understand his desire or purpose for wanting to recuse himself, but I do not believe he has the authority under the code to do so. And even if he did have authority to do so, under the proper code section, it is the governor of the state of Iowa that is supposed to replace him on this panel, not Secretary of Agriculture. And I believe the attorney for the objector is in agreement with that position. Thank you.
Mr. Bolt?
We appreciate the time of the panel and looking at this issue under the shortened circumstances. I believe that the statute is candidly a bit clunky, and as the Supreme Court has recognized, our election laws aren't always a math quorum that always make perfect sense. So I think there is a reading of it that the backup, so to speak, for the auditor under these circumstances would be the governor. I also think there's a very credible reading that the statute does not apply at all, and that the panel has precedent, as I understand it, to put the Secretary of Ag on the panel as well. So the issue was flagged for the panel, and we appreciate the panel looking at this issue. Again, under the shortened time constraints, we genuinely appreciate the work that has gone into this. I would simply note that if the motions are sort of contradict one another. If Secretary Pate is required to recuse, then the auditor would seem to have to recuse as well under the same theory. I think Auditor Sand clearly has, under the common law recusal doctrine, has a personal stake in this matter. I think it was appropriate for him to recuse, and I would leave it to the panel's discretion to determine his backup under its reading of the statute.
Any questions from the panel? I would move that we overrule this objection as well.
May I request the findings of the panel or the reasons in writing,
Yeah.
please?
Yes, those are issued after we issue a written decision after the panel, and that is something that can also be appealed to district court, and that would be addressed in that decision. All those in favor say aye.
Aye.
All those opposed say no. I vote aye as well, and I'll hand it back to the secretary. Secretary, I'm glad to do this one too. It's just the final motion related to subpoena authority. So we'll hear from the person making the motion first, Mr. Hurd.
Yes, thank you. Again, Attorney General Bird. So two of the objections raised by the objector directly relate to the conduct of Danny Phillips, who is an election specialist in the Secretary of State's office. First one being the affidavit of candidacy for Jules Cutler. There is a factual dispute as to what happened on June 12th. June 2nd, thank you. Ms. Phillips I've been provided two affidavits for Ms. Phillips, but I do not believe the panel can consider those unless she is here present to be cross-examined or directly examined. And I do believe under 17A, or this panel is an agency or a unit of state government under 17A. This is a contested case as it directly affects the liberties and rights of individuals in this state and whether or not they can appear on the general election ballot. Probably some of the most important individual rights of not just the candidates, but also the people of Iowa. And if under 17A, an agency in a contested case shall issue subpoenas upon request of the party. I have requested Ms. Phillips be subpoenaed for her testimony today, twice at a minimum, and tried to have her served today. And without her being present, there is no way for this panel to get to the truth of the matter in the factual dispute as to the affidavit of candidacy. The 17A clearly applies to this panel in my opinion, and the Iowa Supreme Court in the 3 previous substantial rulings on appeals from this panel's decision have assumed that this panel is an agency under 17A. It has not decided that matter, but it has assumed that it is. And then additionally, objection number 4, the notarization of the candidate's affidavit of candidacy for Mr. Gluba is another issue that directly involves Ms. Phillips and her carrying out her duties or functions as an employee or as an election specialist in the Secretary of State's office. And without her being present, I don't believe the objector will be able to meet their burden on those objections, and that this panel should not consider any affidavits of her or any other evidence relating to her unless she's here to provide testimony and be examined. Thank you.
Just to be clear before we go to Mr. Poole, because this is an informal proceeding, it's my understanding that she does plan to come here today to answer questions. This is not a formal court, but she will make herself available for questions, so that is going to happen. It's also my understanding that any request for subpoena, that sort of thing, happened very, very late in the game. I think some as late as maybe last night or today even, and so it's my understanding that she's going to come here and make herself available to answer questions relating to her job and how it relates to this case. So please, Mr. Bull.
Sure, thank you very much. I would say respectfully, it's less clear whether 17A applies to this panel. If you look through the definitions in 17A of agency and contested cases, frankly, this panel is rare and this panel is special. And so I think as Mr. Hurd indicated, the Supreme Court has not definitively stated that this is a 17A proceeding formally. That being said, the affidavits of Ms. Phillips, I believe either have been in the record. I'm certainly able to move them here today. And I think the question is there anything else outside of competing affidavits that this panel would need? I would submit no, and that it could be done on the writing. Of course, if Ms. Phillips is here or able to be questioned in person, I think that obviously just makes sure that the panel can consider whatever evidence it needs for the objection. But otherwise, that might actually resolve the problem without anything further.
Any questions from the panel? Okay. So it's my understanding that Ms. Phillips is here willingly and as part of her job, and once we vote on this particular motion and we take up the objection, she's glad to answer questions about her job and how it applied in this particular instance. So let's go ahead and do the vote on the motion. Secretary Naig, do you move that we overrule this motion? Would you like to move? there's a motion relating to subpoena authority that was filed by,
Requesting that we.
yes.
I would
Unless
say
you
it's a-
withdraw
I would
it.
say it's a moot point if she's
Yeah.
here.
Do you withdraw your
Sure.
motion then? Okay, thank you. That makes it easier. We'll just note that the motion, the third one was withdrawn. Thank you. So I'm going to preside over this part at the request of the secretary, although the secretary certainly could preside over this. He's not recused in any way. So, would just like to recognize the objector. If you can, give us your argument for your objections and what we would need to know.
Very briefly, Attorney General, thank you very much. I'd like to recognize that Mr. Kevin Aerosmith is in the room, resident of Waukee, Iowa. He, there was some discussion of standing earlier. We believe Mr. Aerosmith has standing. He's, a resident of the state, an eligible elector, and filed this objection timely. So as to standing, we believe that clearly applies. As you've alluded to, there are 4 objections that have been filed. We think each is an independent basis to sustain. But obviously, we'll discuss the affidavit of candidacy issue because we believe that is the clearest route here, and in our opinion, dispositive. As you know, at the most definite or the most general level, each candidate for office must file nomination petitions, and they must file an affidavit of candidacy. This objection does not relate to those nomination petitions, only to the affidavit of candidacy. It provides basic information, but it provides legally significant and important information about the candidate and the promises that they make throughout the process. For example, if they win office, they will take the oath of office, they will follow campaign finance laws, they're only running for one office. So in other words, the affidavit of candidacy transforms this individual, this eligible elector, into a candidate. It is legally significant. This is not a case where an affidavit of candidacy from Ms. Cutler was defective or it was incomplete. It was not submitted on June 2nd. It does not exist, and it was not filed with the Secretary of State's office. I understand there's some questions, and we'll get into the circumstances there. But let's just assume, because it is undisputed, I believe, that no affidavit of candidacy was filed. It's fatal. Ms. Cutler is a lieutenant governor candidate. She is required to file the affidavit. Under section 45.3, each candidate for office shall complete and file a signed, notarized affidavit of candidacy. Shall is mandatory. This is a requirement individual to Ms. Cutler as a lieutenant governor candidate. In other words, this is not the governor candidate's responsibility. This is not a joint effort. And 2 are needed, 2 affidavits. The Secretary of State's guidance on this issue is quite clear. It acknowledges that governor and lieutenant governor candidates, for a large part, file on the same team. But on page 7 of the guidance, it confirms Iowa law that says that a second affidavit of candidacy is required from the lieutenant governor. So 2 affidavits are required. There were none filed for the lieutenant governor by June 2nd. Just 2 years ago, the Iowa Supreme Court instituted a strict compliance standard. This is not a circumstance under which substantial compliance happened. It did not happen anything at all. And it's too late to remedy the situation. Under section 44.4 of the code, the filing deadline was 5 p.m. on June 2nd. Section 45.3 says that affidavit must have been filed at the same time as the nomination petitions themselves. And the failure for the lieutenant governor to file an affidavit of candidacy does knock out both candidates. They are a package deal under Iowa's system. That's section 45.1 of the code. The governor and the lieutenant governor file together. To the extent the panel is interested, the North Dakota Supreme Court has dealt with a very similar situation in which a governor candidate was on the ballot. Their lieutenant governor did not file the required paperwork, and the court said because there's no lieutenant governor candidate eligible, the governor was knocked out as well. Same logic here. Either they're both eligible or neither of them. And finally, the obligation to follow this statute, to submit the affidavit, that's on the candidate. That's not on anyone else. Election officials are not required to ensure compliance with the laws. The candidates are required to ensure compliance with the law. I'd like to do my best at addressing what I believe the arguments are going to be from my friend Mr. Hurd before they happen. I think 2 points that I would draw this panel's attention to. One, that the panel can only sustain objections to the nomination petitions themselves, that this panel cannot sustain an objection because an affidavit of candidacy was not filed. I think that's incorrect. It's retread on an argument that was made 2 years ago. in the Gluba decision, 2024 Iowa Supreme Court case. The parties there said, well, you can only sustain an objection if it's in law that this objection can be sustained for so-and-so reason. The Iowa Supreme Court said that's too narrow a reading of our precedent. If the affidavit of candidacy was not filed here as it was required, then the nomination papers are legally insufficient. They cannot go onto the ballot. The second point, I believe, as I understand it, is kind of a concession that the affidavit of candidacy was not filed on June 2nd. And we're just going to the reason why it was not filed. That the petitioner, or excuse me, that the candidate should be excused from filing. There are significant problems with this argument. In general, Iowa uses a strict compliance standard. The only exception to that is called good faith reliance. Was there information that was told to the candidate that kind of excuses their failure to follow the law? There's a variety of reasons when courts have looked across the country at this issue. There's a variety of reasons why that exception does not apply in this case at all. There must be affirmative error on the basis of the election officials. Affirmatively, undisputed that the candidate was told wrong advice. We don't have that here. 2 affidavits, which I believe are in the record, unless you tell me otherwise, state that at no point did Julia Cutler present, hand over, or attempt to sign or submit an affidavit of candidacy on June 2nd when these papers were filed. In the other cases, there's an old Iowa Supreme Court case where they talk about when you can rely on election official misconduct. There was no dispute, there was no question that the candidate was misinformed. There was the number of signatures needed on a petition. And that's not the case in this instance. The official must also have statutory authority here. I think the Secretary of State's office is not under no legal obligation to provide legal advice to candidates. I believe it's commonly done, but the question really is the Secretary of State's office advising the candidates informally, or do they have an obligation to do so? The Alaska Attorney General has looked at this in the past, and they've said that the failure to volunteer advice does not result in any wrongdoing. There was no authority there to waive a mandatory requirement. That does not constitute an excuse here. Most importantly, if the candidate's going to rely on bad advice, and that hasn't been established here, it must be objectively reasonable. It is not objectively reasonable to rely on a stray statement from the Secretary of State's office when the code requirement is clear, when the Secretary of State's office is clear. So even if this candidate was misled, it's not reasonable. The Minnesota Supreme Court dealt with a similar issue in 2012. The candidate just forgot to put their phone number on a paperwork there. And the court looked at it and said, this requirement is in statute. The Secretary of State's office or the election ministers were under no obligation to provide legal advice. We require strict compliance. This thing wasn't filed, so therefore the candidate cannot appear on the ballot. This case follows suit. And finally, the failure to do something here, file the affidavit. It must be something that's required by the official's conduct. Now, this is not the candidate's own inaction. Here we just have the candidate not filing something that they need to prove. So I assume that's going to be the exception that's relied upon, and I'm here to tell you we don't think it applies. We believe Iowa requires strict compliance, and that it was not followed in this case. So we believe that the objection should be sustained on this ground.
Mr. Bird?
Yes, and just for a point of clarification, are we just addressing the affidavit objection right now, or are we going to get to the other objections, or what's the procedure?
I think let's deal with the affidavit first, if that helps us to focus, and if you could focus on your legal argument, and then Ms. Phillips is here and can answer questions after your legal argument.
Yes, and before I go into my legal argument, I would request a declaratory ruling from the panel on whether an objection can be made to an affidavit of candidacy versus nomination petition.
Well, that's the heart of what the objection is here. So that would be prejudging the decision before we made it.
Fair enough.
You're free to make a legal argument if you want to. If you want us just to move forward on the legal aspects, we can do that, but I want to make sure you have a chance to be heard.
And should I question Ms. Phillips now or after my legal argument?
If you could make the legal argument, and then I think we'll move to Ms. Phillips answering questions.
Okay. All right. The position of the objectors is that Ms. Cutler failed to turn in her affidavit of candidacy. That is not what happened. Ms. Cutler tried to turn in her affidavit of candidacy at the time the nomination papers were turned in for Nicholas Gluba as well as his affidavit of candidacy. It was Ms. Phillips who declined or refused to accept her affidavit of candidacy, and informed Jules Jules in the presence of Mr. Gluba, as well as another individual whose affidavit is in the record, that it wasn't needed. That is good. Ms. Cutler not turning in her affidavit of candidacy is not only good faith reliance, but it was refused by the Secretary of State's employee. The objector notes that the law is clear on whether a lieutenant governor candidate is required to turn in an affidavit of candidacy at the time of the rest of the nomination papers. But I would point to page 7 of the 2026 General Election Candidate Guide, where it says that a lieutenant governor candidate should file an affidavit of candidacy. It doesn't say shall, it says should. And if the code was clear, that guide would be clear as well, and it says it should. The objector also notes the 2024 challenge before the Iowa Supreme Court, Gluba v. This panel. That was not a challenge to an affidavit of candidacy. That was a challenge to a nomination certificate by the Libertarian Party. Again, not an affidavit of candidacy that was challenged in that case. And not only is there good faith reliance by Jules and Mr. Gluba by not turning in her affidavit of candidacy, the actions of Ms. Phillips in accepting the nomination papers for Mr. Gluba and Cutler was a statutory reliance by Ms. Cutler and Mr. Gluba. Iowa Code section 45.5, sub 5, requires the person reviewing nomination papers to reject them if the affidavit lacks any of the following: candidate's name, name of the office sought, including their district if any, signature of the candidate, and the signature of a notary public under Iowa Code Chapter 9B. Ms. Phillips did not reject the nomination papers when she reviewed them. She accepted them. If she had done her statutory duty and rejected them, or let me back up, if there truly is a requirement for the lieutenant governor affidavit of candidacy to be turned in at the same time as the nomination petitions and the candidate for governor's affidavit of candidacy, Ms. Phillips should have rejected those nomination papers at the time she reviewed them. She accepted them. If she had refused or rejected them, then the follow-up in Iowa Code section 45.5 sub 6 would have allowed opportunity for Ms. Cutler to provide her affidavit of candidacy within the time allowed or required by statute that they be turned in by. The fact that Ms. Phillips did not reject them, did not give an opportunity to cure, and Ms. Cutler and Mr. Gluba had no notice that their nomination papers would be insufficient. That alone is grounds to determine this as a good faith reliance or a statutory reliance on an action of an election official. A case very similar to this reached the Iowa Supreme Court in 1977, Wiener v. Urban. In that case, as Mr. Bull indicated, that was a challenge to a person's nomination petitions, not having a sufficient number of signatures after a recent legislative change. In that case, the election official accepted the nomination petitions, even though there were not the statutorily required number of signatures. The Iowa Supreme Court found that Mr. Urban relied on the election official who made the mistake because the election official had a statutory authority over acceptance of the nomination papers. That's the exact same case that is happening here. Ms. Phillips had the statutory authority to accept or reject the nomination papers of Mr. Gluba and Mrs. Cutler pursuant to Iowa Code section 45.5, sub 5. Ms. Phillips accepted the nomination papers, and Ms. Phillips told Jules that her affidavit of candidacy was not needed. The proper course of action, therefore, would be to allow Jules to file an affidavit of candidacy, as long as it's filed prior to the general election. And as the Iowa Supreme Court said in Wiener v. Urban, as a general rule, unless the statute directly or expressly declares that a particular act in question is essential to the validity of the election or its omission, or that its omission shall render the election void, statutory provisions in regard to nominations are not regarded as mandatory, in the sense that non-compliance with them vitiates the election, but only in the sense that officers or persons to whom they apply are obligated and may be compelled to comply with them prior to the election. An affidavit of candidacy is not something that is necessary for the voters to determine or the failure to provide an affidavit of candidacy is not something that will confuse voters, deceive voters. Voters, the signatures or the signatories on the nomination petition don't even know that Jules Cutler's affidavit of candidacy wasn't turned in. But they do know when they signed that Jules Cutler's name was on the nomination petitions for all counties and all the signatures, all 8,000 plus of them. And again, I'd go back to the request for the declaratory order. I do not believe the Iowa Code allows the objection panel to sustain an objection on a nomination petition. The Iowa Code section 44.4, which governs this objection, which again requires the auditor of the state to be part of this decision. Objections can only be made to the legal sufficiency of the certificate of nomination or nomination petition, or two, to the eligibility of a candidate. An objection to the affidavit of candidacy does not fall into either one of those categories. And again, the 2024 case, Gluba et al. Versus this panel, was not a challenge to an affidavit of candidacy. It was a challenge to a certificate of nomination. Yeah, and additionally, I did make a open records request requesting the Republican and Democrat affidavits of candidacies for their lieutenant governor. I have not been provided those. I assume that there's a good reason I haven't received those, but at this point, I think that an objection would be sustained to both Rob Sand and Zach Lane's position on the general election ballot, because I don't, as of right now, there's no confirmation that their affidavit of candidacy has been filed, or that their lieutenant governor candidates have been filed. For those reasons, the panel should resist or overrule the objection in ground 2 of the objection relating to Ms. Cutler's affidavit of candidacy.
All right, just in the interest of moving towards the heart of this matter, if there's no questions from the panel about these legal issues that were just raised, should we go ahead and get to the factual issues and see if Ms. Phillips can answer some questions? Is that all right with everybody? Okay. Well, we'll go ahead and do that. If Ms. Phillips can come, and the order we're going to take the questions is the panel will ask questions, then the candidate, representative, and then the objector. Okay. And, oh, there you go.
Okay, so since it's our understanding that a party to this objection must come to the panel to request a subpoena.
There's no subpoena.
Right.
She's coming willingly. Yep.
Right. So any questions asked don't have to be vetted by the panel.
So, no, I think, this is an informal process, and so certainly if the questions get too far afield from the candidate or the objector, if the same thing is repeatedly asked, we're not going to do that. But as long as the questions actually relate to the heart of the objection and what happened, that's fine. And I will say, if it does get out of hand, we won't permit that, and I don't think anybody would contemplate doing that. But if it does, the panel will stop it. But I want to make sure that people have a chance to be heard. There's a major difference in what people believe the facts to be, and so I'm very thankful that Ms. Phillips is here and has made herself voluntarily available to be here and answer those questions. So we'll certainly make sure that they relate to the business of the panel and that they're not repetitive and certainly not abusive. She's here willingly and glad to answer these questions as part of her job.
Okay, thank you.
And may I request she be placed under oath before questioning?
No, I mean, you can, but this is not a court proceeding. You will have access to a district court after all of this, but this is not a court. I'm not a judge. We're not judges. This is an informal process, and you already have a signed affidavit as well. But it's not the practice of this panel to swear in witnesses. Okay. So I can start with some questions if the panel would like, if that's all right, and then if any other panel members have questions, then you would go next, and then we would go to the candidate, the objector. So, Ms. Phillips, thank you for coming here today.
Can you hear me? Okay.
Yep, you can make sure it works so you feel comfortable there, so great. Well, thank you for coming. Can you say what your name is, just so everybody knows who you are and what your job is?
Yes, my name is Danny Phillips, and I'm an election specialist for the Secretary of State.
And how long have you worked in the Secretary of State's office?
A little over a year and a half.
Okay. And what is your job as it relates to elections?
I receive and reply to emails and phone calls, election related.
As part of that job, do you also accept petitions or other paperwork from candidates?
Yes, when I'm told.
Is that part of your job duties there in the office?
Yes.
Okay. And do you remember accepting paperwork related to the Gluba Cutler petition?
Yes.
Okay. Do you remember what day that was?
It was on election day, the primary, June 2nd.
June 2nd? Okay. And it was before 5 o'clock?
Yes.
Do you remember, and if you don't remember something, just say you don't. We certainly want you to tell us what you remember from the best of your recollection. But do you remember what paperwork you received for that petition nomination?
I received his affidavit of candidacy as well as the first page of his nomination papers.
Did you receive anything else?
No.
And what did you do with what you received?
I reviewed at face value and then stamped and stating that it was received.
Did you give any kind of paperwork back to Mr. Gluba or Ms. Cutler?
I only gave back copies of his affidavit of candidacy, his first page of his nomination, as well as the receipt.
Do you recall were you ever offered an affidavit by Ms. Cutler?
No.
Were you ever asked whether she should file an affidavit?
No.
Do you have anything else about your work in the office that day that you think would be helpful to the panel to know, or did that cover it?
I covered it.
Covered it? Okay. Any questions from any other panel members? Thank you. Okay. Mr. Hurd, if you have any questions?
Yes, thank you. Ms. Phillips, how did your affidavits come to fruition? What was the process in making those?
Making the affidavit?
Yeah. How did, or let me get more specific. Did you write or type the statements contained in your affidavits?
No.
Do you know who did?
Iowa law?
What?
Iowa law?
No.
Just, Mr. Hurd, I think it's a little confusing because we're talking about affidavits. Are you talking about Ms. Cutler's affidavit, Mr. Gluba's affidavit, Ms. Phillips' affidavit that she signed? If you could be more specific, I think it's a little tough to know.
May I just provide her copies of her affidavit?
You could provide a copy, but I think if you'd reference which affidavit you're referring to, it'd be helpful.
Okay. So, Ms. Phillips, the affidavit that you completed on, I guess this doesn't have a date. So the affidavit where you state that Ms. Cutler did not hand you an affidavit of candidacy, did you type up this affidavit yourself?
I don't remember.
Okay. You signed that affidavit. Do you remember signing that affidavit?
Yes.
And do you recall, do you recall, or do you know who in the Secretary of State's office typed up this affidavit, your affidavit that you signed?
I don't believe that I am allowed to discuss that.
Okay. Okay. But you did not type it up yourself. Can you say that?
No, I did not.
Yeah, I think she already answered that
Okay,
too.
fair
Can we
enough.
just also get to the facts here? There's a big factual difference, so if you could try to focus on the factual dispute, that would be helpful.
Yeah, okay. How good is your memory of what happened on June 2nd regarding the turning in of nomination papers by Mr. Gluba and Jules Cutler?
How good my memory is?
Yeah, would you say you have a very clear understanding, clear memory of what happened that day?
Yes.
Okay. When did your notary commission expire?
2028.
What month?
I don't remember.
Okay. If your notary signature on, say for example, Randy Fingstra's nomination or affidavit of candidacy says April 9th of 28, do you think that's right?
I don't know.
would you notarize, or when you notarize something, do you make sure that you know the document that you're notarizing was signed by the individual?
Yes,
Okay. And do you always confirm that your commission expiration date is accurate when you write it on a notarial certificate?
yes.
Okay. Then why did you include on Nicholas Gluba's affidavit of candidacy that your commission expired in June 27, 2028, when every other notarial certificate you put on governor's affidavit of candidacies say your commission expired April 9th, 28?
I don't remember.
Wouldn't that indicate you don't have a clear understanding of what happened, or clear memory of what happened on June 2nd regarding the turning in of the nomination papers of Mr. Gluba and Cutler?
I do remember him coming in with his papers, yes.
Do you recall who else was with them?
No,
Was there anyone else with them?
I do not know.
Was Miss Cutler there?
I do not know.
Okay. Do you recall checking Mr. Gluba's identification before he signed his affidavit of candidacy?
Yes,
Do you recall accepting the nomination papers?
yes.
And during your short tenure at the Secretary of State's office, had you ever received nomination papers from a candidate or combined candidates for governor and lieutenant governor of a non-party political organization?
No,
So this was your first time?
yes.
And for party, political party nominations for governor and lieutenant governor, are they required to turn in an affidavit of candidacy? Is the lieutenant governor candidate required to turn in an affidavit of candidacy?
Can you please repeat that again?
Yeah, sorry, that was a long question, my apologies. For political parties, like Republicans, Democrats, when their candidates for governor or lieutenant governor, and lieutenant governor turn in their nomination papers, does the lieutenant governor candidate have to turn in an affidavit of candidacy?
Does the lieutenant governor, at the time that the governor is turning in paperwork? No,
Do you know why?
I don't know.
And when you accepted the nomination papers for Mr. Gluba and Ms. Cutler on June 2nd, did you know that an affidavit of candidacy was required for the lieutenant governor candidate?
I don't remember.
Nothing further.
Mr. Bold, did you have any questions?
I don't have any questions. Thank you very much for being here.
Well, thank you, Ms. Phillips, for being here and for answering our questions. We appreciate your patience and providing us with that information. Thank you. Any questions from the panel for the objector or the candidate here today?
Well, I wouldn't mind going back, I keep coming back to this, the idea that what's the remedy for this, right? There's no affidavit, it is required. So how that's a sticky problem, right? What's the resolution to that issue? One is required, there is not one. What's the remedy?
Is there a question for that?
I don't know. That's what I'm thinking about. Do you have an answer?
I have some comments and I believe an answer. The code's not clear that a affidavit of candidacy for the lieutenant governor candidate of the governor-lieutenant governor combo is required at the time of filing the nomination papers. It's definitely not required for political parties at the time the gubernatorial candidate is filing their nomination papers. I will say that the remedy is easy. Ask Jules or require Jules to turn in an affidavit of candidacy prior to the general election. There is more than sufficient time for that lack of affidavit of candidacy to be cured. And I believe that the act of the Secretary of State's office accepting the nomination papers of Gluba and Cutler combined candidacy that in and of itself should be determined by this panel to mean that it was accepted and therefore valid, and it is presumed valid. Their nomination papers are presumed valid. Because, again, under Iowa Code section 45.5, sub 5, it's the duty of the Secretary of State's office to reject nomination papers that are insufficient or are missing signatures or affidavit of candidacy. That was not done in this case. They were accepted. There's no way that Nicholas Gluba or Jules Cutler knew their nomination papers were insufficient for not having an affidavit of candidacy for lieutenant governor. And that's enhanced by the fact that the person reviewing those papers refused to accept the affidavit of candidacy that Jules Cutler tried to present to her, in which she indicated it was not needed. I would note for the panel that there are exhibits filed with the written response of Mr. Gluba and Jules Cutler. In particular, the actual affidavit of candidacy that was that Jules Cutler brought to the Secretary of State's office on June 2nd. And if you would notice, it's a little bit wrinkled. That is because after Jules Cutler was unable to turn in that affidavit of candidacy, she brought it back to her office and put it in her shred box. And then after this objection was filed, we had to pull it out of her shred box. And you will note, I will note that my affidavit is in the record as an exhibit in which I testified under oath, or affirmed under oath, that I created both the affidavit of candidacy for Mr. Gluba and Ms. Cutler about 30 minutes, 45 minutes to them departing to the Secretary of State's office. I did it. I know I created both of their affidavits of candidacy. I know Ms. Cutler took them down to the Secretary of State's office. I was not present at the Secretary of State's office for the interaction between Ms. Phillips and the candidates. An intern at her office thought it'd be cool to see this process. She went down there with them. She signed an affidavit under oath affirming that what's in her affidavit is true. And her affidavit says that she witnessed Jules Cutler attempt to provide her affidavit of candidacy to Ms. Phillips. Ms. Phillips declined to accept it or refused to accept it and informed Jules that it wasn't needed. Mr. Gluba also signed an affidavit attesting to the same thing. Whether or not a candidate's position or a dual candidate's position on a general election ballot can be decided or determined by one election official's memory should not be allowed. Like, that should be a red flag to everyone in this room. If one person can literally take a candidate for governor with 8,000, two candidates for governor and lieutenant governor with 8,000 petition signatures off a ballot, that should be a red flag for everyone. That's a problem. And especially considering this is an employee or the office of the Secretary of State's office, I'm not renewing my motion for him to recuse himself, but I think there's some issues with him deciding this objection in particular. Thank you.
Thank you, Mr. Hurd. Did you have further questions?
I had another question. Thank you. I appreciate that. And Mr. Bowl, you did spend some time in your comments about, whose duty is it to comply. But on this question of 45.5.5, nomination papers shall be rejected if the affidavit lacks any of the following. What we have here is a complete lack of affidavit, not that it was missing something. So I guess in one reading, you could say it was missing all of these things. Should it not? Should those nomination papers not have been, should they have not been rejected because that affidavit is missing? In its entirety. I mean, I get this. This is a distinction around pieces of it missing. This is in its entirety.
Yeah, and I'll circle back to your original question because they're related. I think if the code says, under these circumstances, nomination papers should be rejected, that's one thing. If it's another, under either 43 or 44 that says, here is when this panel needs to sustain an objection and remove somebody from the general election ballot, that remedy is clear. So I'm not sure whether or not, I think obviously it's very much a factual determination, should these have been rejected or not. At the core of it though, as of 5 p.m. on June 2nd, I think it's undisputed at this point, no affidavit of candidacy was filed. So two things to think about. One, under section 45.3, each candidate shall file an affidavit. The rest of that chapter makes clear that a lieutenant governor candidate is a candidate who has to file an affidavit. 45.1 talks about offices of governor and lieutenant governor. 45.6 talks about the offices of governor and lieutenant governor. So again, the shall of the language is mandatory. So the question is, what should this panel do? If it's undisputed that there is no affidavit in the record, again, I go back to the Gluba decision. Should the panel not sustain an objection when the papers are legally deficient? where they're saying, well, you can only address the nomination papers, you can't address the affidavit of candidacy. What's the incentive for any candidate next cycle to file an affidavit of candidacy? There isn't one. If it can't be ruled upon by this panel, no one would file them. So I think that's what the court is getting at in the 2024 decision, to say, you're not the legislature has not limited your ability to sustain objections. They've brought one specifically, and they've said, well, obviously, if there are other legal objections or legal deficiencies with the papers, you can sustain those objections too. So that's what the Supreme Court would say about what the remedy here is. It's sustaining the objection and removing from the ballot.
Did you have something you want to say? I want to just note a couple of things, because election law is sometimes a little bit confusing about the differences between being a major party with the Republicans and Democrats. They have certain requirements they have to do when they achieve major party status versus nomination by petition by another party, for example, the Libertarian Party. And I think some of the things that were said here today are a little bit confusing, so I want to make it clear. Obviously, the Republican and Democrat candidates for governor don't file nomination petitions with their lieutenant governor on it. They just file for governor, and then after their state conventions ratify their choice for lieutenant governor, then my understanding is an affidavit is filed by the secretary's office, and I think that deadline's sometime in August. Okay, so very different processes there. There are different code sections and different ways of doing things. And I also wanted to note that I think nobody's arguing that just accepting papers means that they are legally valid and upheld. That's the whole purpose for the objections panel, so that an objector can come in and make an objection, that can be heard, and that objection is either sustained or overruled. There might be some things that are rejected at the time of filing, but that's not the usual way of doing things, and it's certainly not a requirement on the staff to make a legal determination at the time they're accepting paperwork just before a deadline. So I think those are two things that are important to note, and just from my personal perspective, I think this comes down to a factual issue. I think there's a factual issue that appears to be very much in dispute. Ms. Phillips says that the affidavit of Lieutenant Governor was never offered as part of the petitions. Ms. Cutler and others say that it was offered and it was rejected as not necessary by Ms. Phillips. And so in a factual determination like that, and I want to note, either party doesn't like what this panel does, they can go to district court and have a full and fair legal process in Polk County District Court. That's important that you know that's always an option for whichever side might not agree with the vote of the panel, whatever it might be. But to be clear on that, I tend to side with the election worker, because I don't think she has a reason not to follow the law. That hasn't been seen here. As she described it, I think that that affidavit, for whatever reason, may not have been filed. Now, that's a factual determination, and people can disagree on that, but that's when I look at that and I'm weighing the evidence that's been presented to us. That's where I come out on the matter.
May I be heard on that subject?
Do you have a motion?
Yeah, I can move the motion.
I'd like to be heard on that particular motion portion. We've heard from Ms.
Ms. Cutler,
Phillips.
just a minute here. So, I'll let you talk for a little bit. I mean, we're getting ready to vote, so if there's something more that you want us to know, please, we want to hear you, but then we're going to proceed to a vote on this.
I appreciate that, and I appreciate you giving me an opportunity. I only need a couple of minutes. There are several things. Ms. Phillips, Attorney General Bird, as you just mentioned, that the election law may be confusing. And Ms. Phillips has not been employed by Secretary of State's office for a long time, and I am willing to give her benefit of a doubt that this was a mistake. It is confusing. If you look at the history of the petitions that she affidavits of candidacies that she notarized, all of them were for primaries, and they did not include the lieutenant governor's name, and it is natural for her to make a mistake, and I'm willing to give that to her. What I would really appreciate the objection panel to look at is her memory. Today, she testified that the one thing that she remembers is that I didn't give her the affidavit. She did not remember that I was present. Members of the press who are present here today were there. I was physically present to submit the petitions, but she does not remember that. She does not remember whether who drafted the affidavit for her. she does not remember her notary stamp expiration, the commission expiration date. She made a mistake on her notary expiration on Mr. Gluba's affidavit. Is it possible that she doesn't remember that I handed her the paperwork? Yes, it is very possible, it is quite likely. I have no reason to lie as well. I have the paperwork with me. I had both of the affidavits in my briefcase, provided one for Mr. Gluba. I had to take them both out from my purse to figure out which one I'm giving because Mr. Gluba was the first one to sign. And then the next thing I did was said, and here's mine, I am the lieutenant governor candidate. And the response was, that's not needed. For somebody who just spent several months ago notarizing multiple primary petitions and affidavits of candidacy, it is understandable to make a mistake. But for her to not even remember that I was there's plenty of proof that I was. And again, there's plenty of pictures that were taken by the media, and there were interviews. I physically was present, but she doesn't even remember. So is it possible she forgot about me turning her the affidavit of candidacy? Absolutely. And that's what I would appreciate the panel considering. Thank you.
Thank you, Ms. Cutler. Did you have a motion, Mr. Secretary? Sustain. It's been moved that we sustain the objection. Any discussion from the panel? All those in favor say aye.
Aye.
All those opposed say no. The objection is sustained, and for that reason, we won't go through the other three grounds in the objection. Thank you very much.
May I ask?
I want to thank the panel.
Just one quick clarification. Is the objection to these candidates being removed from the general election ballot, or is there still the opportunity for the party to nominate a lieutenant governor pursuant to the provisions of Iowa Code 44?
So
Okay.
that's not a question that's before this panel. The panel, though, will be issuing a written decision so that all the parties have that for all the decisions here today, should you wish to appeal to district court.
I want to thank the panel for their time today. That concludes our business. We are adjourned.